Jarvis v. Swans Tours Ltd 1972 EWCA. It is an English contract law case on the measure of damages for disappointing breaches of contract. Mr. Jarvis was a solicitor for Barking Council. He chose to go for Christmas holiday in Switzerland. He got a brochure from Swans Tours Ltd, which for Morley Alp, Giswell said the attractions were house party center with special resident host. Morley Alp is a most wonderful little resort on a sunny plateau. Up there you will find yourself in the midst of beautiful alpine scenery, which in winter becomes a wonderland of sun, snow, and ice, with a wide variety of fine steerons, a skating rink and exhilarating toboggan run. Why did we choose the Hotel Krone? Mainly and most of all because of the Gemütlichkeit and friendly welcome you will receive from Herr and Frau Wiebel. The Hotel Krone has its own Elfut bar which will be open several evenings a week. No doubt you will be in for a great time when you book this house party holiday. Mr. Wiebel, the charming owner, speaks English. In a special yellow box it said, Swans House Party in Morley Alp. All these house party arrangements are included in the price of your holiday. Welcome party on arrival. Afternoon tea and cake for 7 days. Swiss dinner by candlelight. Fondue party. Yodeler evening. Cali farewell party in the Elfut bar. Service of representative. It also stated, hire of skis, sticks, and boots. Ski tuition. 12 days £11.10. Mr. Jarvis booked 15 days with a ski pack in August 1969 for £63.45, including Christmas supplement. He flew from Gatwick to Zurich on December 20, 1969, and returned on January 3, 1970. He found the house party was only 13 people in the first week and none in the second week. Mr. Wiebel could not speak English. As Lord Denning MR said. So there was Mr. Jarvis, in the second week, in this hotel with no house party at all, and no one could speak English, except himself. He was very disappointed, too, with the ski ing. It was some distance away at Giswell. There were no ordinary length skis. There were only mini skis, about 3 feet long. So he did not get his ski ing as he wanted to. In the second week he did get some longer skis for a couple of days, but then, because of the boots, his feet got rubbed and he could not continue even with the long skis. So his ski ing holiday, from his point of view, was pretty well ruined. There were also no Swiss cakes, just crisps, and little dry nut cakes. The yodeler was a local man who came in work clothes and sang 4 or 5 songs quickly. The Elfut bar was empty and only open one evening. Mr. Jarvis sued for breach of contract. The trial judge awarded £31.72, as the difference between the value paid and the value of the service received, half of what was paid for. Mr. Jarvis appealed for more. Lord Denning MR held that Mr. Jarvis could recover damages for the cost of his holiday, but also damages for disappointment, the distress, the upset and frustration caused by the breach. He said old limitations on damages for distress and disappointment are out of date. Accordingly, £125 was awarded. Edmund Davies LJ and Stevenson LJ concurred. Jarvis v. Swans Tours Ltd has been called the Donahue v. Stevenson of tourism law. English contract law. Measure of damages in English law. Addis v. Gramophone Co. Ltd 1909 AC 488. Jackson v. Horizon Holidays Ltd 1975 3 Ollie R 92. Farley v. Skinner 2001 UKHL 49.